May I say welcome back. For those who are aware that we are running a series of various topics, we are back with a third theme, and this time we're looking at POPIA or POPI Act. That's how it's commonly known as. It is the Protection of Personal Information Act, POPIA. Once again, welcome. Sam Zima is my name. This is COMETSA Global Online Channels. We have subject matter experts here around the issues of governance, compliance, and ethics. We call it Governance, Compliance, and Ethics Network, the LEKGOTLA Way. We have listened to Lerato talking about the managing organizational ethics for business sustainability. That was our first segment. In the second segment, we had Emily talking about governance in terms of King 4 codes. And we are now going to talk about the Protection of Personal Information Act. And the guest speaker for us is not much of a guest. He's a regular, George Mutendadzamera. George, let me ask the colleagues just to say hi and then hand over to you to take us through this important topic.
Thank you.
Who wants to say hi to the viewers before George takes over?
Hi.
Hi, everybody. Thanks for staying with us this long.
Hi, everyone.
Welcome back. Welcome back. Over to you, George.
Thank you. Thank you very much. And if you joined us right from the start, it's really been an inspiring morning. We kicked off with Lerato and Emily came in. And the whole theme, as you can see, is we're talking ethics and how it benefits an organization. We went zeroed in on the King reports and corporate governance, very critical. And now we're going to talk about one piece of legislation. We could have talked about Companies Act, we could have talked about anything else, but today we chose to talk about the POPIA Act. And I think the reason is it's a very topical piece of legislation right now. And most of you would have attended many, many webinars, Zoom calls, read articles on it. And so we're going to unpack a bit. You've heard it before, but as they say in learning, repetition is the key. That's how you get to ingrain things into your mind and be able to apply. So my name is George Mutendadzamera. I'm an executive business and life coach and a business consultant. My background is I'm a lawyer by training, practiced 10 years, as I always say to guys. Went into corporate, legal advisor, and occupied many, many roles, including board positions, chaired boards, and trained people in corporate governance and other things. So, yeah, I've been around the block, as they say. But we're going to use that to help each other with viewers as we continue on this journey of learning, because learning doesn't end. So what is POPI? What is the Protection of Personal Information Act? So the way I'm going to approach it is I'm going to do a quick intro and then go through what the provisions say, the history of it, and really at the end of it, what I think is the most important part is how do we proceed from now? So if you're a small businessman listening, you are an individual listening, how do we go forth from now? So, we live in an era that is data-driven. If you look at where we were 25 years ago and where we are now, it's a world of difference. Information now, sharing data can make life easier, much easier, more convenient, and much more connected now, both at home and at work. But the data law sets out what should be done and make sure that everyone's data is used properly and fairly. That's the key, properly and fairly. your information must be used properly and fairly. So if you're a small business or a medium business or large business, you will have personal data about your customers, about your clients, such as names, addresses, contact details. You might even have sensitive information, such as medical data, all that in your possession. And you may need to deliver this, deliver goods and services, but you shouldn't use it in ways that people wouldn't expect. So if I go around and give you my information, there's a certain expectation that I have that you're going to use my information fairly. And so when I talk to people about POPIA, I always say, look at it from the angle of yourself as the consumer. You have gone out, you've given your information to somebody else. How do you want that person to look after that information? Because when legislation comes, because we are all small business people and we complain that, oh, it's extra workload on us. Now, how am I going to do this? How am I going to do that? Sure, that's a concern. But if you switch and you look at it as a consumer, you realize, actually, this is something that's very, very important. I must do it not only in a selfish way, but also to look at other people, how they would benefit. So generally speaking, data protection laws apply to workplaces, business ventures here in South Africa. It also applies to when you employ a handful of staff, or even if you don't employ staff at all, it's still data. So running a one-man operation might even seem different from running a huge organization that's listed on the stock exchange. But the rules will apply the same in terms of how do we handle this information. Okay, so that's a little bit of background. And let's talk about where did this whole thing start? For you who have been following this information around this issue around information, will know that as way back as 1995, I think the EU had, the European Union had what they call the data protection laws. And in fact, their laws, the EU's laws, have been regarded for many years as the gold standard all over the world. If you're looking for leads and guidelines in terms of data protection, the EU's laws are the go-to. So in 2016, the EU adopted the General Data Protection Regulation. It's famously known as GDPR. I mean, if you talk to people in this, they know the GDPR, which was replacing the 1995 Data Protection Directive, which was adopted at a time when internet was still at its infancy. If you remember 1995, nobody knew we would be where we are now. And so it wasn't as applicable as time went on. And this became law on the 24th of May, 2018. And you will recall in South Africa, there was talk around replicating this. And this is what has happened. But what was one of the big kickers for this? Let me tell a bit of a story, because that probably would place the importance of data protection into perspective. If you recall, in 2018, an employee of an organization, his name was Christopher Wiley, a former employee of Cambridge Analytica. He gave interviews to The Guardian and the New York Times and disclosed that an organization, Cambridge Analytica, was using personal information irresponsibly. So what happened then is that personal data belonging to millions of Facebook users was collected without their consent by a British firm, the Cambridge Analytica, and predominantly to be used for political advertising. So they built a psychological profiles on users who would hopped onto their app. They harvested, believe you me, 87 million Facebook profiles. I mean, that's an incredible number. We all on Facebook with showing pictures of hamburgers, etc. But these guys had taken that information and built 87 million profiles. They then used this data to provide analytical assistance to the 2016 presidential campaigns for Ted Cruz and Donald Trump. All of us will remember Donald Trump eventually won the election and Ted didn't. But as a result of that, as a result of Wiley's disclosures, Facebook, etc., to cut a long story short, were dragged on to Congress. And long story short, Facebook was fined $5 billion by the Federal Trade Commission due to the privacy violations. That's how seriously this matter is looked at. So what does our POPIA Act cover? Well, it covers the protection of personal information processed by public and private bodies. And it introduces conditions so as to establish minimum requirements for the processing of personal information, to provide for the establishment of an information regulator, to exercise certain powers and to perform certain duties and functions in terms of that act, and the promotion of Access to Information Act 2000. It also provides for the issuing of a code of conduct, to provide for the rights of persons regarding unsolicited electronic communications and automated decision-making, and to regulate the flow of personal information across the borders of South Africa, and of course matters incidental there too. So that's the background to that. But how does this apply? How does this apply to you and me? So Section 3 talks around the application and the commencement of the Act. As we all know, after some delays, the Act came into operation on the 1st of July, 2021. And from that date, we are all expected to comply. But the beauty about this, obviously, legislation is that it's a journey. It's not an event. It's you will progressively ensure that you meet all the obligations that are raised in there. But it applies when you process personal information which is entered into a record. And so we all enter records. You go, a client of ours comes to us as a coach, we get your details, madam, where do you come from, etc., etc. That's personal information. But as I said, we must look at it as a journey. And a record is any recording, handwritten notes, phone, CCTV cameras. You go to a building and there's my face there. That's a record that you are keeping. And it also applies when you're destroying that information. So it's when you capture and when you destroy that information. But what is processing? How does the Act define processing of information? Well, it says it's any activity concerning personal information, for example, the collection, receipt, recording, organization, collation, storage, updating, modification, retrieval, alteration, So all that is processing. Just to say that all this, if you Google, it's all there on the internet, etc. But the benefit, as I said, it's we help you repeat it over and over again because you've got to comply. And if I can say, Lerato and Emily both raised something that is very, very important. And that's worth repeating, really, that any organization's reputation depends a lot on how they behave in society. And so an organization that is seen as law-abiding, ethical, will attract consumers who believe in them and who hold their brand in high esteem, and vice versa. If your ethical record is bad, you will lose consumers. And there are hundreds of cases, I think big ones around Nike using child labor, etc., etc. They harm that reputation. And therefore, complying with any legislation is one of the things that one must do. So what is personal information? Okay, so it's information relating to identifiable person, living, natural person, existing juristic person as far as applicable. South Africa is one of those countries with a unique POPIA Act in the sense that it applies to organizations, to juristic persons. Remember, the whole outcry, the whole background to this was it's my personal information which you are using. So South Africa has also said that, well, if my company information is misused, I also have rights, just like the individual will have rights. That's a very important point. And it relates to race, gender, sex, marital status, national, ethnical, social origin, education, medical, all those, that is information. Biometric information, as technology goes, biometric information is also. Any identifying number or symbol. Let me dwell a little bit about symbol. So your organization will have a symbol, will have a brand. That is also protected, which is unique in South Africa. As you know, for those who know intellectual property law, IP law, that's where you protect your brands, you protect your trademarks in that space. But the POPIA has also extended that benefit, really, of protecting your symbol if it is subjected to misuse of information. And that's great because, you know, small businesses with a struggling to make ends meet, still at infancy, they also have IP, which they need to protect. And if they have to fight in courts using complicated IP laws, etc., etc., that obviously would probably lead them to give up their rights because they just can't afford the big battles. But this is an opportunity to also protect your rights. So your personal opinions, views, preferences, all that is information. The views or opinions of another individual about another person, that is protected information. Correspondence sent by a person that is implicitly or explicitly of private or confidential nature, that must be protected. The name of a person as it appears with other personal information relating to the person, or if the disclosure of the name itself would reveal information about that person, that still is protected. So all of that is personal information. Now, I've talked about a symbol being protected and how that might actually help small businesses. But let's talk about the importance of, so I've given you about what is covered, but I want to highlight information that you really must treat with absolute care. And this information relates to sex, race, health, religion, ethnic origin, belief, medical, biometric information. When you are processing this information, and remember what we said about processing. Processing is recording, all those things that we mentioned. You need to be extra careful with this information because it's highly more sensitive, especially also regarding children if you are going to be keeping information that is sensitive. The overwhelming statistics across the EU, where this has been in place for a longer period, similar legislation has been in there, is that about 30 or so % of violations of this legislation is really amongst the small, medium businesses. That's where the majority of them, because obviously your big stock FTSE listed company, they can afford a whole string of lawyers and accountants and whoever, and ethics officers and all those people to do their paperwork, etc. So they get much more protection. And it's the smaller guys, and it's not because the smaller guys want to deliberately break the law. Most of it is really out of innocence. And in fact, there's an example quoted about the very first case in the UK where a business was fined. It was by a small pharmaceutical company. And when this law, in preparation for the implementation of this law, they got all their record from the pharmacy, George's cough and everything in there, and put them in bags and put them outside for the rubbish men to collect them. Some passerby stumbled on the information, and needless to say was looking gleefully at people's records, and being prosecuted. They were actually fined. I can't remember how much they were fined, but they were fined because they hadn't deleted that information in accordance with the law. So violation of things like this, sometimes it's not because guys go out to deliberately flout the law, but it comes as a result of not following provisions that are there. And hence, if you're watching this program today, you're getting that repetition I talk about. Go back and look at your systems and say, maybe what are we doing that we need to correct and to ensure that we don't expose ourselves. So we talked about chapter 3 of the Act being the, shall we say, it concerns, chapter 3 contains the heart. I want to use that word then, the heart of the Act. So let's talk about 8 processing conditions. Remember, we talked about processing, including keeping records, So what are those 8 processing conditions? Because really, if you get that right, you well on your way to implementing this well. The first one is accountability. Okay, so the first, so if you looked at it as 1, 2, 3, 8 steps, the first one as an organization is just to look at, okay, accountability. What is that? Well, accountability means let's comply with POPIA and let's demonstrate compliance. And how do we do that? We put POPIA policies in place. We put the POPIA compliance frameworks in place. We train our people. And if I may say, if you got your employees to watch this program as we are talking today, that is actually part of the training. You don't have, as a small businessman, have to go and hire a consultant to have a half-day workshop with you on this. This, if you can record this, and you're able to say, yeah, I got our people to watch and learn, that is part of the training. And so it pays to listen to COMETSA's podcast. Okay, so that's number 1, accountability. The second one is processing limitation. Remember, we're talking about the processing conditions. Now, this is very important if you're a business person. Only collect as little personal information as possible. Okay, so someone rocks up, I want you to coach me. And the next thing I want to know where the grandmother lives and all that. That's not what I need. I will collect your phone number that I will have, your email address, and the information that is necessary for me to execute my mandate with you. Collect as little as possible. That way you're reducing your own exposure. All right, so we started off with accountability and we moved on to processing limitation. Right, number 3, it's purpose specification. Define the lawful purposes for processing your personal information. So only keep personal information for as long as authorized. So obviously, you must have someone's consent, right, to get their information around their race, etc., etc., etc. Collect information which the law says you must. Collect information for lawful business reasons. And then clearly you must have some record retention policies. And I remember way back in time when I was in corporate, we actually implemented a record retention policy. How do you keep your records? And it doesn't have to just to be electronic records. It can be the papers, paperwork, the old paper in the old files. If you remember our old files, how do we retain that? Do we keep paper all over the place? Anyone who walks in can read confidential information. It's things like that. Purpose specification, define lawful purposes for processing your personal information. Further, now, number 4, go back. Number 1 was accountability. Number 2 is process limitation. Number 3 is purpose specification. Now we're talking further processing limitation. So further processing of personal information must be compatible with the purpose for which it was collected. All right, that's the reason. It must be compatible for which it was collected. I don't want to spend too much time, but it must. So let's our friends Cambridge Analytica, they collect people's information. Oh, lo and behold, they're campaigning for Ted Cruz and Donald Trump. Now that's a violation. I've given you my personal information. The next thing I see, it's being used for another purpose. So there's a limitation for processing. And then number 5 is information quality. Now, what does that mean? That means that information, that reasonably practicable steps to ensure personal information is complete, it's accurate, not misleading, and updated. Really, it must be updated, that information. So it imposes an obligation on me. If I give you my information last year, 2.5 years later, you're publishing it, and it's not updated, it's giving a false image of who George is, problem, right? Right, so we go back, we started off with accountability, processing limitation, purpose specification, further processing limitation. Now we're talking about the quality of that information. Okay. Then the next one, which for me is very, very important, I think this is very, very important, and it's openness. Openness. You see, at the date that I get the information from you, I must advise you what I'm going to use that information for. So I must tell you that your information is for these purposes. And so you will see most of these companies have what they call a privacy statement, a statement that they issue telling you we'll use your information, we won't give it away to this one, to that. It's a privacy statement. So if you Google now, POPIA privacy statement, there's actually the requirements in there. And you can create your little statement in there. It doesn't have to be, done in a complicated manner. As long as it's there, it should be enough. As long as it is open. If I get there and I look at it, there's an openness there. Right. The next one Number 7 is security safeguards. This is important. Personal information must be secured by means of reasonable technical and organizational measures. So we talked about paper lying around all over the place. That's not secure. So there must be, if we put a policy that says, listen, all paperwork must be locked in Mike Molapa's office by 4 o'clock. Lock it, and he's the one who keeps the key, etc. So that is what people understand, and that information is not going to be paper is not going to be taken out and is floating in the streets. And you won't have an example of a manager and his laptop off to a nightclub, parks his car out there. All your information is there in the car, in the laptop. He's booking the night away. A thief steals that information. There are no proper security around that laptop, and before you know it, the whole of Soweto knows your information. That is not putting security safeguards in place. So you need to have these things in place. Management system, a document management system. I'm sure that there are many consultants around town who can give you these things. And issues around information, ensuring that information goes to the right recipient, the security safeguards. Make sure there's safeguards that information meant for me doesn't end up in someone else's space, however you do that. All right, so we're now on number 7. We just finished that. And what were the first one? We started off with accountability. We have processing limitation. We went into purpose specification. We talked about further processing limitation. Talked about information quality, openness. Now we just dealt with security safeguards. And then the last one, which is the 8th, is data subject participation. Now the data subject, which is you and I, have certain access rights, including a right to request its deletion. So in the Act, so I have a right to walk up to an organization and ask, hey, where did you get my information from? I have a right to do that. And I also have a right to say, but actually this information is wrong, it's erroneous, I want you to delete it. I think it's section 23 and 24 of POPIA that deal with that. But that gives you the right to exercise. So it empowers you when you see your information floating around, it empowers you to take certain steps to deal with that. That's very important. But what is most important for me is not so much that it gives you the right to then take action when something goes wrong. That's very important in its own self. But I think what is much more important is that if you POPIA, all organizations follow POPIA to the letter, there will be no need action to enforce anything. Your information will be safe, and everybody carries on their business in the way it should be. And that's what we aim for. So when people listen and attend all these workshops, webinars, the aim is to ensure that your information is properly protected. And when that is done, everyone comments and everybody goes around their business without fear of exposure. It is, nothing can be more painful than information that has been shared in privacy being out there in the open. That nothing can be more traumatic for somebody. And that is as though you'll find with all professions. With my legal background, one of the things that we were told at university is about confidentiality. You keep people's information confidential, period. Done. That information is when it's between you and your client. And that's the way it should always be. You shouldn't have information that shouldn't be in the public domain getting into the public domain. So this legislation, yes, it has some obligations on businesses. There are things that you have to do. But when you look at it in the long term, it protects you as a small business or medium business or large business, and it protects the individual. You don't have to face lawsuits, etc. At the same time, your customers, clients have full confidence in you. They can walk in and give their information without fear that this information will be shared. Okay, I hope this has been useful and been very, very helpful. So what's the next thing? The next thing is privacy statements are an indicator, obviously, of compliance with that openness requirement. Remember, we talked about how you can download it. And I've already talked about how Section 23 and 24 can protect you in cases where information is in the wrong hands or you are unhappy with who has it. There are some additional requirements, and I'm going to quickly talk about that. It talks about trans-border transfers of personal information and direct marketing are stringently regulated. The Act protects that. That's trans-border, that is taking information outside of the borders of South Africa. And all security compromises must, as a general rule, be notified to the information regulator and, of course, to you as the data subjects. So what are some of the additional requirements? So let's talk about, so we all get these SMSs or emails asking, I'm selling this, I'm selling that, and yeah. You have a right actually to block that. You have a right not to have your email shared with the seller of whatever product and etc. That you can. But the Act also is a bit less stringent about what they call telemarketing. Remember, telemarketing is a form of marketing that allows companies to connect with potential customers via telephone. And so someone phones you, hey, I'm selling this and that. And you say, where did you get my number from? You have a right to demand, but it's less stringent than the automated version of it. The one thing that, let me give you an example of what can go wrong. So if, for instance, I have an invoice with all the details of your details, and it says date of birth, where you live, everything. And I send it, instead of sending to you, I send it to maybe your neighbor by mistake. That is actually a violation. It is, and those are the things that will happen, and they happen because people are not paying attention. But by training, through regularly hearing these messages that please don't do that, you will empower your staff not to get into that. Yeah, sure, mistakes do happen, but those things are important, and they come from exposure to training. All right. How are we doing for time? Right, I think we are okay. So the Act imposes an obligation by creating the office of an information officer, So what the Act says is that the CEO of a company is designated as the default information officer. And there are certain compulsory duties which the information officer must fulfill in order to ensure POPIA compliance. These things are, as in, if you go for somebody, you will have all that in terms of what are those obligations. But of course, if you're a CEO listening down, don't freak out and say, oh, because you can authorize another information officer to fulfill the function. I saw some freaking out a little there. You can actually authorize another person to fulfill the function of the information. So what does that mean? What it means is that you can now delegate the duties to a deputy information officer, but according to the information regulator, CEO remains liable for compliance failures. Okay. As those are the advantages of being a CEO. When the company fails in its implementation of regulation, they don't say, okay, so which junior did you actually ask to do it? They simply come to the CEO. And clearly, the intention there is obvious, so that the organization takes it seriously. If you delegate it to the guy at the gates, and then when things go wrong, you simply point at him, no one will take it seriously. So it's you can see it means, well, it protects the company, you must remember that, and it protects the data subject, because it's at the right level, the responsibility. And of course, the information officers and deputy information officers must be registered with the information regulator. You can't just, between the two of you. I gave him a call and I told him that he's now the information officer, and there's no record anywhere to show that that happened. You must actually register that. And these are not onerous things. They irritate doing it, but once you do it, it's done. You're not going to be asked to. It's done. So these are things that I think we should do. So what should we do now? Okay, that's why you sitting there. You say, okay, George, it's all very well. You're telling us all those things, but what should we do now? All right. So what should we do now? Number one, appoint an information officer. We've talked about that right now. Because in the absence of that, the head of the organization is the one. And obviously, clearly, the CEO is inundated with the strategy, etc., etc. So find somebody who can do it in the organization, and that takes care of that. Then develop data protection policy. Develop a data protection policy. You do it once, it's done. You're not going to doing it every other day. But just dedicate time to say, listen, this is what we're going to do, and that takes care of it. Make certain mandatory disclosures to data subjects, including with whom their information is shared. If you're in the business where that information is going to be shared, make sure somebody knows who is going to see their information. I think that's straightforward. It helps you going forward. Now, conduct personal information impact assessments to ensure adequate measures and standards exist to comply with the conditions for the lawful processing of personal information. Remember, we talked about processing means keeping records, CCTV, everything. That is processing of information. Anytime you capture it, that is processing. But what is being said here is do your own impact assessment to ensure adequate measures and standards exist to comply with the conditions. The beauty of this is that when you do it once, you're there, and all you're doing now is a refresher. You're training people, guys. Remember this, remember this, remember this. And having come out of corporate myself, been in there for 20-something odd years, all officers and I'm too busy with my line of work. I have no time to come to those things. And that's what causes problems in organization. And so if you're listening, whether you're large, medium, or small, this is something you literally put a policy that, guys, you are going to listen to me, because when things go wrong, we don't want finger pointing. We don't even want things going wrong. This is important. So what else can we do? Develop, implement, and maintain a POPIA compliance framework. Once you do that POPIA compliance framework, you do it once, done. And then obviously the duty then going forward is to ensure that that compliance we refresh people's memories about it. We talk about it, people understand. Okay. Within that, there's a requirement for what they call the PIA manual, PAIA, which is required by 31st December 2021. Okay, so what to do now? Look into what do I do with the PIA manual. So if you're listening, PAIA manual, what do we do? It's required by 31st December. Let's talk a little bit about what they call operators who require special attention. And the easiest way to talk about that is to give an example. So let's say you're setting up a new IT framework, etc., and you got these contractors coming in. They're going to obviously be exposed to all your information as they do all this. And if in their process they have a leak going out and your information goes out, you want to have special attention and to have a contract with them to ensure that that information doesn't go out and create problems, because the law will hold you liable. You can't say, oh, okay, we did the very best, but look at this contractor. He is the one who went to Polokwane to get all the information out there. No, you can't do that. You must create a relationship with Mr. Operator understands, so you have a special contract with that. That's very important. What else do we need to do? We've got 10 minutes to go. To develop, monitor, maintain a manual as prescribed by the Promotion of Access to Information. That's the manual I talked about earlier on. Include certain mandatory provisions in your agreement. So I've talked about the third parties. I'm not going to go over that again. In some instances, prior authorization must be obtained from the regulator, including where the responsible party transfers special information or information of children to countries without adequate data protection laws. The moment you see the word children, look for someone to help you with that, because that information is regarded as very, very sensitive. I think earlier on we were talking about holding children on camera as we're doing our programs. The law is very, very sensitive around children, folks. So if you're listening and your business has something to do with children, be very careful around that, about the information you capture, how you look after it. It pays you to just get some experts to say, listen, this is what I'm going to do. How can we ensure that we're protected? Not just for you. Remember that there's a young life there that needs your protection. And therefore, we are extra careful around children. Okay, and then finally, really what you can do is to conduct internal awareness and training sessions. Very, very important. I know companies, we have no money, etc. Well, get some video and put it there, get your employees in a room and let them watch that.
Absolutely.
But the point is, get your people to understand the provisions. Sure, when we talk here, we don't give you the full gamut. Section 2 says this. We don't. We give you kind of like the highlights. But that is a good starting point. Then you can then go further and do more around that. Okay, so what are the benefits then of me complying with this if I'm an organization? Well, it saves you time. Let's say if you handle your information right and from the start, you don't make mistakes, you take what is necessary. It saves you time tomorrow on issues that may arise. For example, if you avoid hoarding data you don't need, remember that, don't hoard data you don't need. You significantly have lesser files to search through when you're looking for information you actually need and to run your operations efficiently. Don't keep stuff that you don't need. Destroy that, get rid of it. It just, because let me tell you, even when you have ceased working on a particular case, as long as you have that individual's information, you're regarded as processing his information. Remember that. So take a look. I don't need this, out it goes. I don't need, out it goes. Because if there's a leak, and the last time you did it, this information was a year ago, but the leak, well, you still held liable because you're processing that. So, see, when data processing goes wrong, it can also be costly. You could lose your customer database, which could mean you're unable to fulfill orders, and you could be prosecuted or sued. Prosecuted by the man who runs the POPIA Act, but you could be sued by the aggrieved individual. So you could, whilst you're bending this side from the law, somebody is suing you on this other side. So you don't need that. It's a much better idea really to be proactive. That's really all I want to say, is to be proactive, take steps to help stop people's data from getting lost, damaged, or stolen. Be proactive, make sure you don't open people's information to misuse, abuse, or what other way do you want to use. All right, folks, that's about POPIA Act, but really just to say to you, please ensure you comply. It's a bit of a nuisance with any piece of legislation to comply fully, but do yourself a favor, comply. You're protecting not only the reputation of your business, you're also protecting the individuals who come to you because they trust you, they come to you because they want to do business with you. So ensure you also look after them. Okay, and that's about it. Poppy.
George, so you said that this act is progressive. It's a journey. So is the enforcement of it also progressive, or is it?
Well, what I mean by that is that as a business, don't say I must get everything done tomorrow and fully done. The regulator isn't out there rushing to prosecute people. That's not what the regulator is looking at. The regulator is looking for you to ensure you're protecting the interests of people. Sure, at some stage, I'm sure the regulator is going to take out his stick and look for people to deal with. But it came into effect, as I said to you, 31st of July. So it's just a few months down the road, and clearly the intention, as I understand from the is not to prosecute people, but it's to ensure that we are protecting each other in the process. I mean, if you haven't done this in 2 years, 3 years, I'm sure all of us would have no sympathy for an organization that does not follow the law. We've already been talking about following the law here. Those are the things the board should be saying. Poppy, where are we with that in the board meeting? And officer says, this is where we are, we've completed, we've done this, done. That's the responsibility of board members. If the board member has been trained well by Lerato and Emily, then they know their duties.
So so that's my last point for clarity. If I'm a global company operating in South Africa and let's say I'm headquartered in Europe, so will you recommend that the GDPR will be sufficient, covered, or you still need to do those disclaimers that are specific for each of the two?
So a company that's headquartered in the EU will be governed by the EU. But if you have operations in South Africa, where the law of South Africa applies, but because there's so much similarities, what you probably would be doing is just to add on to ensure that you're compliant in South Africa.
Because I can imagine that with companies that centralizes their procurement offices somewhere else, they buy all over the world, or they do business all over the world. They might say, "Look, we are British, or we are okay. Britain is no longer part of EU. Let's take
France."
France."
Well, Sam,
yeah.
let me not say I'm fully expert on that aspect. I haven't actually done a research on that. I must be honest with you. But when I look at how the law applies, the South African legislation will apply to you if you are operating in South Africa, unless there is an express provision in the law that allows you to follow another law. And I don't remember that there is in this one. But as I say, I haven't done research on it, but it's a point that if you are an organization that's headquartered outside of South Africa, you may want to look at. Whichever way you look at it, though, the bottom line is that you must ensure compliance with the provisions to safeguard yourself and the other businesses.
Okay. Emily, you want to say something?
Just to thanks. Just to add on to what you just said, George, it is true that you would have to comply dually. The companies that are headquartered overseas, they have to comply with the South African law, and then they have to definitely comply with the international law, with the law in the US or in the UK, the GDPR. So if, for instance, the company that I work for operates internationally, you have to comply with the GDPR. For instance, if you are working in EU, in the European Union. But the thing is, like you said, George, the similarities are such that it will be a marginal additional compliance to the GDPR that you are doing. You just obviously, in big companies, you have compliance officers who go and research what the provisions are for the particular law. What is it saying that we can or can't do? And then you tick off. Literally what you do is you create a Excel spreadsheet and say, they are saying 1, 2, 3, 4, 5. We'll be in trouble if we do 1, 2, 3, 4, 5. And here in South Africa, they're saying we'll be in trouble if we do 1, 2, 3. So we must ensure in South Africa, we don't do 1, 2, 3, 4, 5. In the EU, we do 1, 2, 3, 4, 5. But I was just responding to Sam. The thing that I wanted to ask clarity on, George, this POPI Act, it looks like there's two types of information. You know, it segregates information. Says there's private personal information and public personal information, and the information that it seeks to protect is the private personal information, meaning the organizations who don't handle a lot of private personal information don't necessarily have an issue, because the fact that an organization dealt with me and they know my name and surname doesn't put me at risk, because everybody knows my name and surname. But if an organization is like a bank, or I think they pointed out like your NPA, the National Prosecuting Authority, for instance, like this whole thing that has come up with President Jacob Zuma, with the NPA knowing, disclosing information about his medical records. Those are the things that organizations are required to protect. You cannot disclose medical records. You cannot disclose like bank account numbers, things that are private personal information. So when you are in an industry, when you operate in an industry that doesn't handle anybody's private personal information, you are less at risk of being of breaking the prescripts of the POPI Act. But if you deal with private personal information, things that people generally wouldn't know about the next person, that's when you have to focus on knowing
That's right.
what it says you can or can't do.
But the general principle is make sure that you don't conflict with the act, because you might be in a project that forces you to keep somebody's personal information and unintentionally be conflicting with the law. I think the awareness is what is important, and then protection, or what do you call it in risk in management, the mitigation against potential risks is also very important, because you don't know when you're going to need it. So it's like that disclaimer statement that must just be filed and always be ready for.
And most importantly, Sam, in organizations that don't handle other people's private personal information, you also handle your own people's private personal information, like your
Yes, you employ people.
finance person, your HR person. In other organizations, those are the people that need to be. So whenever you are in a position where you handle people's private personal information, that's when you've got to be very alert and know that you can't use it for unlawful processing. You can't give it to people who don't have a legitimate reason to process it.
That's right.
Okay, beautiful. Colleagues, we are top of hour now. It's our lunch time. I think we're going to take a lunch break, and then we're coming back at 2:00. We're going to do a reflection. That is the best part. We're going to reflect on what we have had. And then, of course, we're also going to formally check out before we leave. Now, the reflection, we are interested in giving a reflection on each of the three themes, including your own theme, but more so interested in the reflection of the other people's theme. And then from there we consolidate, and then we can then come up with some things that stand out, that are quite very important for our practice out there. And then when we check out, we're going to check out with those 5 points what was confirmed for us during the session, which is very important, because the purpose of this Lekgotla, or Lekgotla in general, is for us to try and really pick up what we have confirmed for ourselves and for the sector and for our viewers there. And what did you find as the light bulb moments? They've had a lot of light bulb moments, which for me, it makes me quite very excited. I want to hear your light bulb moments, because sometimes certain things don't always appear obvious. And then, of course, what new knowledge, new insights have we generated, not only for ourselves, but for this topic? Because sometimes, if we don't raise I sense there is a sense of agency out of this, but there's a lot of people who still think, no, it's okay, it's one of those who will just tick the boxes. But this is about the behavior, it's about governance, it's about compliance. Actually, it's going to change the culture in the way we do business. I think especially for small business, you don't want small business being sued for things like this, because now we will destroy the good intentions we have by encouraging people to become entrepreneurs. So what are the new insights and new knowledge that we're picking up? And then what are the take homes? I always say that the take homes are the things that really you want them to be eaten immediately. When you are in a restaurant and the food is cooked, you only ate a bit of it, and there's somebody at home who will really enjoy this meal. You can't. Well, some people have they take doggy bags, but But not every food you take from the restaurant is a doggy bag. It's for some other people to really to enjoy what you have enjoyed. And so what do you want to take with for other people who could not be here or who might not have listened to enjoy this? And then lastly, which is very important for me, there must be a shift in our way of looking at things, in our behavior, in our practices, as a result of this knowledge that we have kept collected. What do we think we must stop immediately doing? I mean, I'm a coach, so one thing for sure I know that we are obligated by this law to keep information safe. Now, not everybody can afford to put information in the cloud, or even if you put in the cloud, if your security is weak, people can breach, they can hack into your phone and then get access to your codes and get people's information. So things like so. Those 5 points for me, it's almost like we are reviewing, but we are not reviewing. It's a reflection basically, and that's what the panel is going to be about. And there are some few comments that are coming from the viewers out there, appreciating and say, thank you for the great session on POPIA, much appreciated. That comes from Luis Lepan. Very important discussion, POPIA Act. That comes from Fenze Maseko. And there is an emoji there from Jerry. So yeah, so people are appreciating it, and I think we must continue talking. Business is not just about our functional technical expertise, but these other things that have nothing to do with what we've learned as engineers and as coaches and as consultants. Once you start business, all these things now becomes a burden, and they can actually stop you from progressing. And let's help people, and I think it make people realize that you can't be stopped. I mean, I know, and not intentionally. I know clients who start business and then they can't sell because they come. Suppliers start business, can't sell because the client wants ISO standards. Now you can't get the ISO standards. Or ISO standards could be just the occupational health law or POPI Act or POPI policy or POPI strategy. So this is available. Yeah. Let's discuss that when we come back. Yes, Emily.
No, it was, I just wanted to make on the ISO standards a point, but I'll put it in the reflection.
Yeah, let's discuss it in the reflection. Otherwise, we will eat into our lunch.
We won't go to lunch.
Yeah, okay. We'll see each other at 2 o'clock and we'll take it further to closure. Thank you.